Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a case from the Fifth Circuit, which I think is an interesting take on the official immunity doctrine, and it's also a terrible story of how somebody was abused by the law enforcement community down there. Let's take a look at this opinion from the Fifth Circuit. Hey, if you're enjoying this content, please feel free to like and subscribe. It really helps the channel and makes it possible for me to continue to do this. That's it. That's the commercial. So this is a case of Don Frank as the representative and individual on behalf of Armando Frank, who is the person who suffered in this particular instance. And it's against Keith Parnell and all of the sheriffs of Aeolus Parish in western Louisiana. So this is from the Fifth Circuit. And it says, before the court is the appeal of a grant of summary judgment based on qualified immunity for appellant's excessive force claim. The district court held that the officer's use of force, including tasers and chokeholds, was not unreasonable under the facts of this case. We vacate and remand. Armando Frank, a mentally ill, disabled veteran, was a lifelong resident of Marksville, Louisiana. In this town of approximately 5,000, Frank was known as the man on the tractor because he drove his red tractor around town. On October 20th, 2017, Frank drove his tractor to the Walmart for a personal errand. As he sat on the tractor in the parking lot, he was approached by deputies Brandon Spillman and Alexander Daniel of the Aeolus Parish Sheriff's Office, where Marksville is located. They parked their vehicles directly in front of Frank's tractor to prevent the tractor from being used as a means of escape or a weapon. About the same time, Officer Parnell of the police department arrived on the scene. Immediately after arriving, Daniel approached Frank, identified himself, and asked for identification. Frank promptly handed him his identification. Spillman and Daniel told Frank they had an outstanding warrant for his arrest and wanted Frank to come with them. Frank repeatedly asked to see the arrest warrant, and Daniel informed him he could see it at the police station. When Frank asked what the charges were, Spillman and Parnell refused to tell him. At this point, the encounter became tense. Frank declared that he wasn't leaving the tractor, and Parnell quickly resorted to force, reaching in from the right to pull Frank off the tractor. Frank provided some resistance and tried to keep Parnell off the tractor. Approximately 30 seconds later, Parnell deployed his taser into Frank's chest for a 5-second cycle. Frank removed one of the taser probes. A few seconds later, Spillman jumped onto the tractor and put Frank into a chokehold while screaming, "Get off of the expletive-deleted tractor." And while Frank was being choked, Daniel deployed a taser and hit Frank in the leg. Shortly after, Parnell performed a drive stun, and in case you don't know what that is, that's where they take the two probes on the end of the taser and put them up against the skin of the patient or of the suspect, and then they project a shock through that skin right there. It's very painful. It's not as disabling as the stun from the little probes, but it certainly is painful. So he drive stunned him, and then he did 2 more minutes of drive stuns. Frank was tased 7 times in less than a minute. Within minutes of the encounter, he was unconscious and, for all intents and purposes, was dead. And he was pronounced dead less than an hour after the incident began. The autopsy report basically concluded that Frank was a victim of 148 seconds of positional asphyxia in the back of the SUV, and his autopsy showed injuries consistent with evidence of manual strangulation. According to Dr. Tape, it's likely that Frank primarily died as a result of respiratory and possibly some vascular compromise due to a struggle with police supported by autopsy and video evidence. Dr. Tape determined that the respiratory compromise consisted of neck holds, strangulation, the body being pressed, compromising ventilation, the body on the ground with hands behind the back and personnel on him, compressional asphyxia, and positional asphyxia, and the body face down with hands behind the back in the back of the SUV, positional asphyxia. Moreover, the tasers likely caused respiratory compromise by paralyzing the muscles of ventilation, including the chest, abdomen, and accessory muscles. The addition of the pain being shocked likely stopped effective breathing, at least temporarily. So the family sued, and then, as they pretty much always do, the officers moved for qualified immunity. And the district court found the defendants were entitled to qualified immunity and dismissed the case. The Fifth Circuit, however, wasn't quite so convinced. Consistent with our standard review for summary judgments, the legal issues underlying the district court's qualified immunity ruling is reviewed de novo. And once an official pleads the defense, the burden shifts to the plaintiff, who must rebut the defense by establishing a genuine fact issue as to whether the official's allegedly wrongful conduct violated clearly established law. Qualified immunity shields federal and state officials from money damages unless a plaintiff pleads facts showing that 1, the official violated a statutory or constitutional right, and 2, that the right was clearly established at the time of the challenged conduct. The court may rely on either prong of the defense in its analysis. When an excessive force claim arises in the context of an arrest or investigatory stop, it is most properly characterized as one invoking the protections of the Fourth Amendment. Such an excessive force claim arises out of the Fourth Amendment. The test applied is whether the force was reasonable. The reasonableness inquiry is an objective one. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them, without regard to their underlying intent or motivation. However, the court cannot apply this standard mechanically. And excessive force is whether excessive or unreasonable depends on the facts and circumstances. After criticizing the district court for not paying enough attention to the video evidence in the case, this is what they said that I found particularly interesting. While all factors are relevant, the threat of harm factor typically predominates the analysis when deadly force has been deployed, so we'll begin there. The district court held that this factor weighed in favor of Frank, as the tractor, which could have been viewed by a reasonable officer on the scene as a threat to safety, was not turned on, was blocked by at least one patrol car, and had a farming implement attached to the rear. We agree. Frank posed no immediate threat to the safety of the officers or the public, was clearly unarmed, had no ability to and never attempted to flee, and was an obese, disabled veteran. Additionally, this court considers the speed with which an officer resorts to force, where officers deliberately and rapidly issue lesser responses when such means are plainly available to them. It's clear from Daniel's body camera footage that the officers made no attempt to de-escalate the situation, but rather deliberately and rapidly issued lesser responses. It took approximately 80 seconds from when Frank handed his ID to Daniel until the officers initiated physical contact. Parnell fired a taser probe into Frank's chest only 32 seconds later. A mere 8 seconds later, Spillman put Frank in chokehold. Within the next 45 seconds, Frank was either shot or stunned with a taser 6 separate times and put in another chokehold. A jury could conclude that reasonable officers would have been keenly aware that this level of force should not have been used in this situation. The threat of harm factor favors Frank. While the remaining two factors do not weigh as heavily upon our analysis, they yet demand attention. Severity of the crime. The district court held that Graham's severity of crime weighs in favor of the officers, as they were attempting to execute a felony arrest warrant. The officers knew that there was a felony arrest warrant outstanding, and that based upon that warrant they had probable cause. In the recent case of Crane versus City of Arlington, however, the court did not find the fact that the warrant was for an unconfirmed felony probation violation and multiple confirmed misdemeanor warrants as wholly dispositive of this factor. Parnell testified that he was advised that an open warrant for Frank was a felony warrant, but that he did not recall if he knew what the warrant was about. Neither Daniel nor Spillman knew or inquired into the nature of the felony warrant. The warrant was for a simple criminal trespass, an attempted unauthorized entry of an inhabited dwelling. Simple criminal trespass is a misdemeanor, and unauthorized entry of an inhabited dwelling is a felony. Daniel's incident report does not state the warrant was for a felony or any type of violent crime, but rather says he was aware of the existence of a warrant. None of the officers arrived at the scene with their weapons drawn or appearing alarmed by the severity of the violation. Any felony warrant does not automatically tip the severity of crime issued in favor of the officers, and in fact, prior case law implicitly recognizes that a felony warrant is not automatically dispositive in this factor. And then actively resisting or attempting to evade arrest by flight. Officers may consider a suspect's refusal to comply with instructions during a traffic stop in assessing whether physical force is needed to effectuate the suspect's compliance. However, officers must assess not only the need for force, but also the relationship between the need and the amount of force used. However, officers must assess not only the need for force, but also the relationship between the need and the amount of force used. So the Fifth Circuit says, here the district court held that it could not say that Frank was only passively resisting arrest. Although Frank's initial demeanor was calm, he became increasingly obstinate when officers did not do as he requested to present him with a warrant. A jury could conclude, however, that reasonable officers would have been aware that they should not have been repeatedly tasing and choking an unarmed, disabled man sitting in a blocked-in tractor. The district court held that Frank reached for the taser, Parnell grabbed his wrist, and Frank pulled his arm away. From the video evidence, there is, at a minimum, a factual dispute about whether Frank was reaching for Parnell's taser or was simply pulling his arm away to avoid being grabbed and tased. Excessive force claims are necessarily fact-intensive. The Fifth Circuit has held that excessive force existed when an officer tased someone who only pulled his arm out of the officer's grasp. Drawing all inferences in Frank's favor, Frank satisfies this factor. Turning to the clearly established right, the officer's conduct violates a clearly established right when there is controlling authority that defines the contours of the right in question with a high degree of particularity. Clearly established law should not be defined at a high level of generality, but it's also not necessary that a previous case presents identical facts similar to this case in order for the right to be clearly established. This is because the central concept is that of fair warning. The law can be clearly established despite notable factual distinctions between the precedents relied on and the cases before the court, so long as the prior decisions give reasonable warning that the conduct then at issue violated constitutional rights. Lawfulness of force does not depend on the precise instrument used to apply it. Qualified immunity will not protect officers who apply excessive, unreasonable force merely because their means of applying it are novel. And after discussing a little bit of case law, the court comes down and says, therefore, the appellees were not entitled to qualified immunity, and the district court erred in granting their motion for summary judgment. So this is an important case, and it's especially important in the Fifth Circuit. I think that it's a good decision, and I don't think you want to go around essentially being a bully when you're a police officer, and that's sort of what's being talked about here. If you look at this from an objective standpoint, the guy was obese, he was sitting on a tractor, he wasn't going anywhere, and they refused to tell him what the warrant was for. It doesn't make any sense not to tell him what the warrant is for. If you've got a valid warrant and you show it to him, I'm sure the guy's probably going to go with you. Or if he's not, then at the very least, there's got to be a better way to get him off of that tractor than by tasing the living daylights out of him. That's what I have for you. If you have a different opinion, let me know. Be happy to discuss it. Thank you so much for watching. And as always, have a terrific day and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.